the zoning appeal. 2023. At this time, I'd like to ask everyone to please silence or turn off your cell phones. My name is Elizabeth Waits. I'll be presenting the cases for the Codes Department today. I would like to make a few preliminary announcements before we get started. Some of the matters on the docket have either been concluded or are being deferred. Case 2022-157 is being deferred 2 meetings to February 16th. That's a request for a special exception from the height and setback requirements for a proposed mixed-use adaptive residential development at 1302 and 1308 Dickerson Pike. So if you're anticipating speaking on that matter today, please note it will be back on the board's agenda on February 16th here at this same location, 1 p.m. Case 2022-160, an item A appeal of the zoning administrator's interpretation regarding duplex eligibility at 946 Battlefield Drive. That case is being dismissed, resulting from administrative approval. Case 2022-164. This is a request for a variance from street setback and maximum building coverage requirements at 3205 Granny White Pike. That case is being deferred 1 meeting to February 2nd. That'll be here at 1 p.m. Sonny West Conference. Case 2023-8 is a request for a variance from the rear setback for property located at 2324 Golden Oak Court. And that case is being deferred 1 meeting to February 2nd here at this location, 1 p.m. Regarding the matters that are going to be heard on public hearing today, please note that applicants whose applications are approved by the board today will have 2 years to complete your building permit. You will receive a copy of the order to you by email on the email address that is on file, or you may contact our office to receive a copy of the order. We have some council members present, and so I wanted to ask Councilman Withers, I believe that that matter on Holly Street is going to be the first item heard today, so if you would like to be heard at that time, thank you. I don't believe there are any other council members present. Actually, Councilman Cash was here, but his matter is being deferred. So for the items, whenever we call the cases up on the agenda, the applicants will come forward first. We're going to call and ask if anyone's here to be heard in opposition to the request. And so if you'll let us know if you would like to be heard asking the board not to approve a request or some alternative other than approving it, then if there's opposition present, both the proponents of the application as well as the opponents will have 10 minutes each. That's aggregate. In other words, everyone here who's being heard in favor of an application and everyone who's being heard against an application, there's a 10 minutes per group. So you'd want to perhaps organize yourselves to make sure how to allocate that time. For cases that are not contested, so if no one raises their hand and says that they would like to be heard in opposition, then the applicants will still come forward. They'll have 5 minutes. When the applicants come forward or opposition parties come forward, if you please press the button, there's like a little person button that whenever you push it, the red light will come on just like this. Please state your name and your address, and then you can make your presentation before the board. The Metropolitan Code requires 4 votes to grant an application. And if a matter receives less than 4 concurring votes, then that matter is going to be put back on the next agenda for a re-vote. Once a vote is taken on your application, a party who disagrees with the outcome may request a rehearing within 60 days. Parties may also appeal the decision to the Davidson County Chancery Court by filing a writ of certiorari within 60 days. All parties are encouraged to seek independent legal counsel before filing an appeal to ensure that all deadlines and procedures are followed. At this time, I will start calling through the cases on the agenda. Thank you. Madam Chair, we're going to call case 2023-10 at this time. This is a request for a special exception to reconstruct a religious institution at 1212 Holly Street, zoned R6. The parcel belongs to historic East End United Methodist Church, which was within the direct impact zone of the March 3rd, 2020 tornado, and has since been demolished as a result of the damage it sustained. The Planning Department has recommended approval of the application. Before you here is the zoning map of the area. An aerial view. In this photo from the property assessor's office, you can actually see the previous structure prior to demolition, as well as the damage that was sustained. Here is a photo of the site as it appears today. It's an empty lot, and the site plans that have been submitted seeking approval. At this time, we would like to ask if anyone's here to speak against this application. Seeing none, Madam Chair, if the applicant would come forward, you all will have 5 minutes, and then we'll also allow for the council member to speak after the applicant has completed their presentation. So among you, whoever was going to speak to the board, if you may please come forward and give us your name and address. It appears perhaps as our presenter in the room. Okay.
My name is Craig Kennedy. Do I need to get my address? Okay. 3700 Brush Hill Road. I'm a member of East End United Methodist Church.
My name is Reverend Brandon Baxter. My address is 1200 Twin Springs Drive, Brentwood, Tennessee, 37027. And I am currently the appointed United Methodist elder that is the lead pastor at East End United Methodist.
So the application is to construct a new church where the existing church resided. The original building was built 1907, was damaged beyond repair in the tornado in 2020 and demolished last spring. And so we're in permitting process to build a new building there. In terms of planning, I mean, the footprint is largely sort of what was there. We're not expanding sanctuary. We're essentially building back what we had before, but that meets codes and standards of today, as opposed to 1907 when it was built. I would say we're sort of here to answer any questions that you guys have.
Can you tell us about the community meeting that you had?
Yes, and actually, Joey, we just emailed that letter. We had a meeting on Tuesday night with the neighborhood. Actually, a number of our church members and rebuild committee folks are East End neighbors, and we didn't have any opposition to the proposal at that meeting. Everyone seems to just be excited for kind of the next step of getting the church back on that hill.
Any questions from the board members?
Yeah. Member, just one comment. The zoning code would normally require that sidewalks be brought into compliance. I have waived those because this was caused by involuntary damage. So they'll be allowed to repair, if there are any damaged spots, we'll need to repair those. But other than that.
Okay, I didn't see any questions from the other board members, and I'm very sorry for what happened to your church during the tornado. And we'll call up Councilmember Withers now.
Good afternoon, and thank you to the board for hearing this today. I want to express appreciation to Metro Planning staff who were able to send a report just now. But obviously, we're approaching the 3-year anniversary of the tornado event where the structure was destroyed. Just to give a little background as well, obviously, our East Nashville community really prizes historic preservation. Did want to state that the East End congregation went to great lengths and even great expense to try to save as much of the structure as they could. That was determined to be not feasible. And then there was a very public process for seeking input for designs of the church building that included not just the congregation, but also members of the broader community. So there has been a lot of community conversation about this in the 3 years leading to today's meeting. This item has been before the Historic Zoning Commission, where it was also approved, and just want to hope that this is the final meeting that we have before they can finally begin the reconstruction process. But wanted to share that community input background on these plans and seek your approval.
Any questions for Council Member Withers? Okay, we'll close the public hearing and discuss.
Seems pretty straightforward to me. They're building back where they were. I think it meets all the requirements labeled for us as special exception. And so unless Ms. Davis has another comment before I do this, I'll make a motion.
The only comment I wanted to make is that I live about half a mile from here, so I drive by this location. I just wanted to disclose that for the record.
Okay, very good. Well, I will then make a motion that we approve special exception as presented.
Okay, we have a motion and a second. All in favor, raise their hand and say aye. Aye. Okay, that passes. I don't see any opposition. That passes 4-0. Good luck and great to hear your church is moving forward.
Next, we're going to hear case 2023-7. This is a request for a variance from the side setback requirements to obtain a building permit for a home addition to a single-family dwelling at 1134 Sonny Drive within the RS 7.5 zoning district. The applicant is seeking to reduce the 5-foot setback to 4 feet and 1 inch. Before you here is the zoning map of the area, an aerial view of the neighborhood, a closer view of the subject property. This is the view of the property at the time that it was, the last photo was taken by the property assessor's office, so that was almost a year ago. It's date stamped. And you could see the porch at the time on the side of the home. This is a view of the home today. And this is the addition that's the subject of the request, as well as some photographs showing this property and the immediate neighboring property, which I believe that homeowner has submitted a letter that the applicant provided with their application, and the site plan that shows the distance. The setback is being requested for about a 1 foot reduction. Is there anyone here in opposition to this case? I don't believe so. And so the applicants, if you would come forward, you have 5 minutes to make your presentation.
Good afternoon, members of the board. Seth Klein of Collins Legal. My permanent address is 1015 Fatherland Street, Unit 205, Nashville, Tennessee, 37206. On the onset, I want to thank you all for approving the prior hearing that we just heard. I also live about 2 blocks from the East End Church. They're fantastic neighbors, and we're very much looking forward to seeing their sanctuary be rebuilt, so thank you. With that, I will move into the incident matter before us. I represent Mr. Dominic Rhoda and Ms. Lauren Kisner, who are here and present today. They're residents of 1134 Sonny Mead. In short, this is a request for a variance setback for the distance of 0.84 feet to 0.9 feet into the 5-foot setback for the if you're looking at your screens, the object that is X'd out on the right side of the property. As was stated, the neighbor, Miss Pigram, to the right in parcel 20, she has submitted a letter in support of the build and is not in opposition. as well as Council Member Ms. Emily Benedict has also submitted a letter in support of this proposed variance as well. Those are contained in your packet that I had given to Mr. Hargis and hopefully have been dispersed. But in short, this is a residence that the appellants purchased on the 4th day of February 2021. So just 2 or 3 weeks, less than 3 weeks before the image that you last saw from the property assessor's website, where the side porch was at that time not under construction or otherwise attempted to be closed in. And right around April 22nd, the appellant submitted a request for a rehab permit in order to enclose this structure. It was initially approved by Metro Codes employee Clint Elliott. However, after the site plan was reviewed, they noticed that it appeared that the side porch encroached into the setback. Again, this side porch, the slab thereof, it was pre-existing the purchase, so this is not a result of the appellant's do first, ask for permission later, or anything like that. This is no sort of undue influence as a result of the appellant constructing a slab and then it not being in compliance. This was already pre-existing. The appellant has no desire to make this into an additional bedroom or otherwise increase the square footage of the property or the footprint. There will be no HVAC, no plumbing, plumbing, heating, or I'm missing a utility here, gas, to the structure. So it would just, in short, be a sunroom. I'm fortunate that both of my clients and I are all Belmont Law grads, so this is the first time I've had the opportunity of representing one of my classmates. They both, Ms. Gisner works for the Attorney General for the state of Tennessee. Mr. Rhoda works for Patterson Intellectual Property. Again, they are first-time home buyers. So in short, they're just looking for a sunroom. Again, I know that a lot of these hearings come down to whether or not it's going to be an additional living space or a bedroom or something of that nature. In this case, the appellants would be more than happy to agree to a covenant or restriction, thereby limiting the use of that property just as a sunroom or additional closed-in space. But in short, this is probably one of the more straightforward requests that I've made, so I don't have a significant legal argument. However, I'm more than happy to answer any questions that the board may have, and or the appellants are happy to do so as well.
From what I understand from the application, the existing porch encroaches less than 1 foot into the required setback.
That's correct. Yes, ma'am. It encroaches 0.84 feet on if you're looking at your screen, the top corner, the top right corner, it encroaches 0.84 feet. And then on the bottom corner, it encroaches 0.9 feet. So less than a foot all the way around.
What age is the residence? And when was it first built?
I would say
when the residence was first built?
I could pull that for you, Councilman. State your name and your address, Lauren.
Lauren Rhoda. My maiden name is Kistner. 1134 Sonny Drive. To our knowledge, when we were purchasing the house, it was around 1940.
Okay, so it was before the zoning code was there. That's what I wanted to know.
Yes, sir.
Yep.
And you ended up here before us today because they went through the rehab permit process and someone flagged this? Or?
Correct. So that was CARR 2022-023739, that permit initially approved by Clint. However, after they reviewed the site plan, that's when they saw the encroachment. They requested, Metro Codes at that or planning requested a revised site plan or a site plan where it showed that it did not encroach. Unfortunately, it's a legal impossibility because it does. We're not disputing that it is an encroachment into the setback. So at that time, Miss Rhoda, I thought you were going by your maiden name still. Apologies. But the appellants, they did have a survey completed in order to find out exactly what that distance was in preparation for this meeting.
Any other questions for that appellant? I don't think we had any opposition, so we'll close the public hearing now. Discussion?
I mean, it seems like a minimal variance on a property that's built long before the zoning code was there. They have neighbor support. It seems pretty straightforward to me.
I agree.
Yeah, so
20% variance, right?
right.
But I totally get where you're coming from on
Yeah.
construction date, prior to zoning, all of that, so.
Yeah. All right. Well, in that case, I'll make a motion that we approve the variance as requested up to, let's say 1 foot, just to give some leeway with construction tolerances. So a 4 foot setback.
Do you want to include anything about not?
That's what I was
Yeah,
thinking, Mr. Cole.
just that it no longer, never be a conditioned space, essentially. Based on the hardship of the kind of unique circumstances of the property.
I'm sorry to interject. I think you might want to hear proof on whether or not it is conditioned space in order to.
Well, they said, in the public hearing, they said that there's no utilities to be brought out there, so therefore it wouldn't be conditioned if there's no utilities.
Okay.
Yeah, you'd have to get some kind of utility out there for that. Yeah, I guess the hardship being the unique characteristics of the property there.
I second it.
Okay, we have a motion and a second. All in favor, say aye and raise your hand. Okay, so that, I see no opposition, so that passes 4-0. Good luck.
Thank you, Board. I wish you a prosperous 2023.
Thank you very much.
The next matter to be heard is case 2022-145. This is a request for a special exception from the minimum residential space requirement for a proposed adaptive residential development at 3706 Clarksville Pike, zoned CL, that's commercial limited. A precondition for adaptive residential developments would be a minimum 40% gross area to be dedicated to residential purposes. The applicant is seeking to reduce the minimum required residential use to 30% according to the cover sheet. I had some questions about the calculation on that based on the site plan. The planning department has recommended approval of this request. Is there anyone here in opposition to this application? I don't believe so. If the applicant would please come forward. And I'll go through our slides. Here is the zoning map of the area, aerial photo. This is a street view of the building that's there now, as well as just a view of the street itself. The calculation for 40% would be 1,650 feet being dedicated for residential purposes based on the building that's there now and the square footage that's provided on the assessor's website. 30% of that would be 1,237. And if I'm reading this site plan correctly, I believe 1025 is going to be proposed as dedicated for residential. And if that's correct, it would be perhaps closer to 25% being requested for residential purposes. But hopefully the applicant can speak to that and clarify it for us. And if you would at this time just state your name and address and make your presentation to the board.
My name is Jermaine Hines, and my home address is 1305 Valley Trail, Whites Creek, Tennessee, 37189. And as far as the square footage process, the original square footage possibly should be more than that. We were also damaged in the 2020 tornado also, so it blew the roof off and some walls. So we had to reconstruct walls on the other side, which is a restaurant. And we were just going through the motions as far as trying to get it done, and we didn't think we was going to have a problem until we had a problem. So the numbers need to be correctly applied to it.
Okay, yeah, just for our clarification, so the residential portion is slightly bigger than the 1025 that was initially contemplated? Okay, all right, and so it would be 30% that you were all, okay, thank you.
So I'm just curious, is, what exactly, what are you trying to do here? Is this like part of the original building? Is this like a new building on the site? Like what's the kind of use of this, adaptive residential use?
All right, well, before it was a vape shop, then COVID hit.
Okay.
And then after COVID hit, it turned back to a hairdresser. The tornado hit, and she had to leave because of the damages and stuff. She didn't have insurance, even though we did. So basically, there's no new. The only addition will be a half wall. The space was just completely just straight open area.
Okay.
In the back, there's a half bathroom already. So the only thing that would need to be put in is a shower. There's already electrical outlets to put any other equipment in there. Where the sinks would be on this drawing, there were like shampoo bowls and stuff for the hairdresser already. So minimal construction would have to be done.
Okay. So this is within the existing building?
Correct.
Okay.
Any other questions? Do you have a question, Joseph?
No.
Oh, your light was on. Everyone's light is on.
Oh, sorry.
That's okay. It happens. So from what I understand, what we need to do today is determine that the relief being requested will not be injurious to surrounding properties. So that's our task today, from what I understand, the zoning code to read. Any further comments?
No other comments. We did have a meeting. One person came and he just wanted to meet us. So nobody had any questions or anything. To the right of us, there's a ATM, SunTrust ATM, Truist SunTrust ATM. And on the other side, it's a Vans Auto Parts store. They're both been there. They're doing construction behind us. They're building some apartments and housing behind us. And all the construction on Clarksville Highway has been done now. So we're just trying to get everything done when that gets done.
Okay. So no other questions? I know.
How many parking spots do you have on site?
Well, up front, there used to be 8, but because they increased the street size, they took our sidewalk basically. Mm-hmm. So we're going to probably get about 8, and we'll have 14 total. We got room in the back also that's fenced in.
So just so that the record is clear, like, I think Mr. Newton asked you, but just so that we have it on the record, how will this space be used in total? Like, I get the proposed site plan, I get what you're requesting, but when you have this building and given the number of parking spaces, like, what's the intent for the entire building? The
intent is just to be like a mini hotel, just a place where a person can stay instead of trying to rely on getting somebody to put their business there month by month. Maybe we can do it, somebody stay overnight 2 to 3 times a month and make the same amount.
Okay. Thank you.
So the intent is like a short-term rental, right?
I don't see any further questions. I don't think we have any opposition in the audience, so we will close the public hearing and discuss. I don't find the proposed use injurious to the surrounding properties. It's an existing building.
And given where it's located, like where that intersection is and the businesses that are around it, I don't think so either. I agree with your assessment. So I can make a motion that we approve the special exception because of the finding that it doesn't injure existing properties and the proposed site plan and stated intent fits within the existing context.
I'll second that.
Okay, we have a motion and a second. All in favor, say aye and raise your hand. Don't see any opposed. We have one.
No.
We have one that is not present for the meeting technically. So that motion passes 4-0.
All right, thank you all. Appreciate it.
Okay, at this time, we'll call the last case on our agenda today. Case 2022-143 is a request for variance from the side setback requirements for a single-family dwelling and for a detached garage at 1042 Scoville Street, zoned R6A. This case was previously heard in public hearing on November 17th. Before you hear, I'm just going to go through the slides to refresh everyone's recollection. The zoning map of this area, an aerial view of the neighborhood. The white building in the middle is the subject property. And the immediate neighboring property, which is discussed in the brief that was submitted by the applicants. This is also a rear view where you can get a sense of the spacing of the detached garages on this parcel as well as the neighboring parcel. And the site plan submitted by the applicant. Is there anyone here in opposition to this request? All right, we do have opposition here today, so the parties in opposition as well as the parties who are going to be submitting this application have, well, actually, we've already had the public hearing, so I should submit to the chair if you would wish to propose how to move forward at this time. Thank you.
I'll propose that we give each side 2 minutes to come back to us with what they discussed since the last time the matter was deferred, to allow both parties to have discussion. And I will say that I was not present at the time. You can't hear?
I'm sorry. Thank you.
Okay. I was not present at the time, but I did watch the video, and let me know what else I need to tell you on that.
Oh,
I looked at the case.
you did have an opportunity to review the footage, and everyone else was present at that time. So I think that everyone is in a position to make a vote if the board is prepared to do that today. And so at this point, of course, the parties are present. At the time, the board deferred this item so that the parties might have an opportunity to discuss and perhaps resolve it if that was their, desire to do so. And so I think at this point, the board might wish to determine whether or not those discussions were fruitful. Apparently, we hear from the neighbors that they're still in opposition, so the board might wish to gather a little bit more information about the negotiations or the status of this request at this time.
So I'm proposing 2 minutes for each side. Is that everyone agrees? Okay, so if you'll state your name and address and give us an update.
Good afternoon. Michael Johnson. I'm with the law firm of K. Griffin, and we represent the owner of the property, JDG Investments. We have not reached an agreement with the neighbor on where the property line is. If you recall, there are competing surveys. And unknowingly, at least based on our client's knowledge, the property 1042 was built within the side setback, both with respect to the unit B on the left and the garage. Now, what we're asking today, though, and I won't speak for the neighbors, though I do believe, based on our conversations, that they're in agreement on part of this, that we carve out and remove from the variance Unit A on the right and the Unit A garage, because neither of those have any issue within the setbacks. That is the residence that our clients are going to individually and personally use as their residence. So they want to be able to take that, get a use of occupancy, take that off their construction loan and close on it. That's A on the right, does not involve any of the setback issues. And then we are also asking that the B residence, that we be granted the variance on that, where it's within, you can see within anywhere between 3 and 4 feet from one of the property lines, the disputed property lines the closest. So the max variance there would be just about 2 feet on the back edge of the property. So we're asking that those 3 units be that the A side be removed from the variance, that the B residence, that variance be granted. And I think the neighbors are on board with that. And then the Fusons, and then that the garage be continued while we continue to try and work that out.
Yeah, members of the board, as far as administratively, and I want to make sure for clarity for everything, on this drawing, we would be talking about removing the right-hand side blue structures from those. I have no problem. We can do that in-house at codes and pull that. That was never an issue to this board anyway. So to the extent that UNOs are being held for those units, we'll take care of that from codes' standpoint. And same true if there's a situation alternatively on the far left red structures, if there are issues with UNOs there. The red gets a little bit more difficult because they are joined. It's a joined structure. So clearly what's labeled in red, the existing carport on the far left-hand side, if there's an issue with that, we can handle that at the department level. I'm a little bit reluctant on the left-hand side unit if there's an issue, because that's the second of the two duplex definitions. One is two separated by 6 feet. The other is two joined with at least 80% interior wall joining. So to respect of the property line, what I'm saying is to respect of the property line, if the red is even at issue, I'm a little bit nervous about UNOs for either of the dwelling units on the red side, because they're, for lack of a pun, they're kind of joined at the hip. They're, it affects. There you go. That was for you, Mr. Bloss. So.
And Joe, just to clarify, what's the process for us to remove the buildings?
Nothing this board needs to do as far as the.
So we don't need to make any motion on any of that on the right side?
Not at all.
Okay.
What's at issue for you would be the setback issues on the left-hand side of the blue and potentially the right-hand side of the red. That here, but I think what's filed is just the blue.
Just the blue side. Yeah. So we're only hearing whatever is on the right side of the blue here, not on the red.
On the left-hand side of the blue.
Yeah, well, yeah, but regardless, this one, that doesn't have anything to do with the red, it's only with the blue.
Okay. Yeah.
Right?
So, if there's any issues with, as far as UNOs for the applicants, folks, for the units on the right-hand side.
We'll give them a second to.
We were just conversing about the process of handling the UNO side, but we'll be able to work on the right-hand side. And to the extent, let's say, coming out of the variance, if the board does not approve the existing garage, you do have remedies perhaps to combine those into a single structure and scoot it 5 feet away. So
that's part of what we're working on with the builder and that kind of thing.
Okay.
Yes.
No, that's fine. I just didn't want to confuse the main issue at hand, but we can remove the right-hand side of that.
Thank you.
Did you have any other comments?
That was it. Thank you.
Okay. Further questions from the board? I think we asked some questions that made it a little slower.
I guess my only question is to hear from you is that this is based on your survey. The main dwelling is no closer than 3.1 feet from what you believe to, or what the opposition believes to be the survey line, and it's 5 foot from where you believe the survey line to be.
That's correct.
Okay, thank you.
Okay, I don't see any further questions, so we'll call up the opposition.
Very good. Thank you.
My name's Patty Fusen, 910 Peconic Place in Murfreesboro, Tennessee. And we are definitely, we want Jamont and them to be able to move into their home. Of course, we still have a problem with the other home that's too close to ours because their garage is only 6 inches from our property line. We have passed all of our inspections, and I have this here if you want to take a look at it. Anybody wants to take a look at it. When we asked for our UNO, they refused it because they said of this meeting right here. So they wanted to make sure that everything was okay with the variance or whatever. They have admitted that their garages are too close. They've already admitted that. We met with the homeowners and the lawyer, and they have admitted that it's way too close, and they're going to do something to remedy that. And we're fine with that because we want all of us to be able to move in. This has given us about a 6 month. This is a 6 month delay, and it's been so expensive. And we are still not being given our UNO because of this variance that they are asking for. So the way I understand it, they're not asking for a variance anymore, but whatever, but because they've admitted that it is incorrect.
Miss, can I ask you a question as regards to that? On this picture here, which of these units are yours?
We're on, I'm trying to see.
1040.
We're the
That
dark
house
house.
on the left.
1044, we're the dark one. And the house is actually, it's not 3 foot, it's like 2 foot 10 inches is the closest that the house is to my house. And I'm not sure what the farthest it is, but it kind of goes back at an angle. So it's actually closer than the 3 foot. And the garage at the farthest, or at the widest, is 6 inches off the widest. On the back part, it's like an inch off. It's literally right on it. Well, I'm not trying to put a privacy fence up to get moved in, but I can't move in because I don't have my certificate of occupancy, which we're kind of being punished. And we haven't done anything but go by the guidelines, the rules, the code. They didn't, and we did, and we're both being punished, which I get it.
They've admitted that, and their lawyers are here. They have admitted that that they put it at the wrong place. He didn't say that, but they have admitted that in our meeting with Michael and the two homeowners. The minute we walked up, they said, "It's too close. We know it is. We're going to do something about it." And so we were like, "That's fine." But we don't mind that they move in next door. But we just don't know why we can't get an occupancy.
We don't know why we're being held up.
As far as the dwelling itself, not the garage, just talking about the dwelling, do you have any issue with a variance being granted to let that be where it is, like
for the house,
for the actual dwelling? Yeah, not the garage, the house itself. We know the garage is.
I mean, not if we're coming to an agreement on something, but if we're not, I mean, if they're trying to fight it, then I mean, it's all too close. So, I mean, the main problem is with this, but the house is still. I'm putting a privacy fence up, and that's going to end up eating it way into there. It's going to be super close. I mean, especially right here. Even if I back it off 6 inches off the property, you can see at the very front of the picture, you can see the stakes sticking out right beside their footers, the top of it. I mean, if I come off 5 or 6 inches, be a half foot. They're not even going to be able to put their brick up or do anything right there. It's going to make it hard for them to move everything, but. I have a dog.
This is the garage. I'm talking about the dwelling, the unit, or the house itself.
I get it. I mean, I'm not. It's just for resale. I mean, my thing is the people buying the house going to want it? Is it going to be a problem for them because their house is too close to mine? So it's all. I'm not okay with it, but my main issues with this. But I do have an issue with that for resale value. I mean, we did all this trying to stay within the code, within the guidelines, and they just kind of threw it up and are asking for forgiveness instead of permission. I wanted to enclose my garages. I wanted to do all that. They wouldn't let me do it.
Okay, thank you.
But the point is that I haven't heard them say that they were incorrect. And that is when we went and met for like an hour or two, they did say, your survey was correct. Our survey was wrong. We're going to remedy the situation. And they are trying to agree to something of whether they're going to move it or what they're going to do.
But we haven't heard from them until today. The surveyor for the lawyer for the surveyor and the lawyer for the contractor. We've talked to Michael, the homeowner's lawyer, but the surveyor and the contractor's lawyer waited till today to try to do anything an hour before court. So we haven't had hardly any time to remedy anything or heard much of anything. We're just here, and that's kind of what we know. We haven't heard anything from them since the last time we were here.
But the point, honestly, the point is that it's incorrect.
And
they don't really even need a variance because they said whatever. But it's incorrect. So we want our UNO. We really need it. We just cannot keep on going on month after month after month while they try to figure out what they're going to do.
It's costing almost $10,000 a month between payments, mortgage payments, storage units, other places to live. And I don't know why we would be the ones getting punished for it by not getting it.
Yeah, I mean, because they've
We
been
didn't do
granted that for the people that own these properties. You said you can grant that. We just really need somebody to
We've had
get.
five, we also had 5 surveys done. We've had 5 surveys and everybody was in about an inch of each other. Their surveyor's the only one who's 5 foot off. And I even told him when I went out there, I said, you're like way off from all the other surveys I've had. Just because you're friends with the contractor, don't let him get you in trouble. He just kind of laughed it off. I'm like,
We were looking for some new testimony today, so if you do have any further.
Are you in a
We just would like to get ours,
Yeah.
especially if they get theirs, because we want them to get theirs. But I guess we're still working on this other house, but we really do need our UNO. Our contractor asked for it on the 6th, I think he asked for it 3 different times, and finally the last time was on the 6th of January. We didn't even get a response until the 12th, and it said pending this meeting. So we need it. We need to move in because
We understand.
it's costing too much money, and it's not our fault. We haven't done anything.
Now, remember, same remedy that I spoke about with the other gentleman. Let me talk with these folks and our building inspection staff as far as UNO off their side as well. And then really all that's before you, we're talking is the variance on the interior unit.
Joey answered my question, so thank you.
And do you need this to know?
Let's talk after the meeting. Yeah,
Oh, okay.
we'll go over and talk to building inspections too.
Oh, okay.
and we don't have an issue with the other neighbors on the other side getting their UNO either. That's fine with us. We want them to be able to move in. We understand it's not their fault. They didn't build the house. They just hired somebody to do it. So we want them to be able to move in, but
I don't know if the appellant has any time left on their 2 minutes. I don't know who's keeping track.
thank you.
Is there anyone that would like to hear from the appellant again?
Yeah, and I would like to hear I would like to hear some of the response that the statements that were made in this testimony.
Okay, then we will, well, right, I don't think there's any further questions, so if you
Everybody
go
good?
with Mr. Hargis.
Thank you. I appreciate
We'll
it very
take
much.
care of
Thank you.
And
Appreciate your time.
we'll call the appellant up, but only to answer questions.
I appreciate that.
Okay, so what questions did we have for the appellant?
So the packet mentions second level in garage. In the packet, it mentions the second level of the garage space and it possibly being a dwelling unit.
No, my understanding is that both garages have upstairs portions, but neither is allowed to be a dwelling unit.
So
So there'll be a bonus room or something like that.
there's not like,
Right.
but it's not like toilets and showers.
No.
No one's sleeping in there overnight.
Right.
Okay.
Okay, other questions?
So, and you can answer this however you want to. Do you agree with the opposition testimony about what was said in the meeting as far as the survey and possibly being wrong or?
Actually, no. We don't know, to this day, we don't know the answer to which survey is correct. Our client's builder built off a survey where the setbacks, if we look at that survey, the setbacks are correct. Once they were in the process of building, the Fuson's building starts going up. This becomes becomes evident, and that's when the parties realize that there are conflicting surveys, and that we have a boundary issue. To this day, we don't know which survey is really correct. I'm just trying to resolve it.
Okay, any further questions? Unfortunately, the public hearing, we're about to close the public hearing and we had given the time already. So the public hearing is closed now.
Thank you.
Discussion.
I mean, I don't see any way that I could support a variance for the garage in the back. I could support a variance possibly for the dwelling in itself. I know that opposition didn't like that, but I mean, if the survey dispute goes the other way, they're gonna have to come back to us looking for a variance as well. I mean, that's at the end of the day, somebody's gonna have to get that at some point. So I don't really want to get into that either. I mean, that may be above our pay grade.
It's just sort of hanging out there.
I think we can give them a decision today on the house, the dwelling, and that way they can occupy if they choose to occupy. That's my thought on it. So I'm agreeing with you. And the garage would continue to be non-permit for both of them.
So do we need to, I guess, make a motion for each separately?
Yes.
The only thing I wonder is I mean, the neighbor has expressed that it could be injurious to him to have it that close.
The dwelling or
the dwelling even so. And I guess I am not an attorney, and so
You get common sense.
Well, but if it was me having this property, developing this property with the intent to sell, I'd want to be compensated for that injury, and if we grant the variance, then I guess provides no avenue for him to be compensated for that injury. But so that'd be my only hesitation there. That it does provide some harm to the neighboring property.
Yes, I'll just give my perspective, living 6 feet from my neighbor. So to me, it's not injurious, but that's just my personal perspective of it. And I think it's more injurious if they continue this out because no one will be able to occupy and who knows how long it'll take to go through Chancery Court. So I think we could give them a decision if someone wants to appeal it to the Chancery Court, then so be it.
If I could ask our superstar across from me, Joey, did you come up with any brilliance in your discussions in the back of the room?
No, we're going to discuss with the director occupancy for their residents as well. It's not as cut and dry as the right-hand side of the blue rectangles was, but.
So the hemorrhaging may slow, but it won't stop, is what I'm sort of hearing.
I don't know sitting here, to the extent if we're able to give them a UNO on their unit, we can. But the property line still, at the end of the day, the property line's the issue. If the judge says, hey, that line's really more closer to these folks, now they're in violation. So I'm a little bit remiss to say, oh, sure, yeah, move right in. And if the judge adjudicates that the line's really closer to them, now they're in violation also with this fellow. So they're right back here in front of you. Now, in the typical business part of things, if a neighbor, let me set this scenario. So if we get a complaint by an adjoining neighbor saying, hey, we think they built too close to the property line, I ask the builder, give me an as-built survey and show me what you got. They've testified they've done numerous surveys and they're all compliant with the zoning code. It would make sense that our department should turn it loose, and if there's litigation that needs to occur between those parties, let them litigate it. The part I don't know in this is whether the effect that the red survey is valid, so that the applicant has a variance before this board, they're okay. I just don't know. I kind of need to discuss that with folks above me. Is that okay to turn that one loose? Whereas the right-hand side of the blue thing is cut and dry. It has nothing to do with the property line. So But we're at least going to go discuss it after this hearing and see.
So if we granted a variance today, does that allow both of them to occupy, or you're saying it's still muddy?
I'm making a presumption here without knowing that all other inspections are holding this event, so assuming everything's great. Yes, I mean, aggrieved parties have 60 days to appeal this board's decision. So you kind of occupy at your own risk, but in a sense, you could. I am torn by the testimony of the adjoining neighbors that from their perspective, they're being held hostage by the situation on the adjoining property. And I do see that point of view. But again, I have to weigh, hey, if this line moves, now you're in violation. So,
Joey, can I ask you a question?
Yes,
then, like, we have testimony from the applicant that they don't actually, like, they're not willing to concede that, which I completely understand that the boundary is wrong, but they also said that they don't really know where the boundary is. And that we're being asked to make a decision based off that boundary that nobody's really settled for me. I guess that's why I'm uncomfortable, because it's like, if I get testimony from one group, because I remember this case and I remember the opposition talking about all the surveys they got. And I remember the applicant talking about the survey that they got. So if I give everybody the benefit of the doubt and they built based off their survey, which is what normal people do, and now it's before us, it's sort of like, I don't know if, are we equipped to decide this when we don't know what the boundary is? Like, because either way, like, someone loses and either side is injured, but I don't really like making decisions like that.
no, I understand that. And I look to our legal counsel to the left of me to if I say something out of line, stop me. My understanding is the Chancery Court has the first, what's the word I'm looking for? The proper venue to litigate property line disputes is the Chancery Court. So this board's not equipped to decide where the property line is.
Right.
It is equipped to grant variances to such case. So I guess ultimately.
But I'm granting a variance based off of the property line. Exactly.
Well, it's the flip of the coin. Okay, if it's heads, then it's one, is what we're being asked to do, and if it's tails, it's the other one, but yet I've got someone that's paying $10,000 a month because they haven't got any place to live.
And essentially, both sides want us to make a decision because they're ready to move in, which I get. I'm so sympathetic to that. But I also, like, if both sides are telling me, well, one side told me they don't know what the boundary is. The other side is telling me what they think the boundary is.
It's 1 of 5.
So that's what I guess my question is like, the variance is based off the boundary. That's what we're being asked to do. But essentially, I've got testimony from two different parties saying they don't know where the boundary is. Not really, but the boundary is disputed.
See what you have on common sense than we do.
I think one party is adamant their survey's correct. I mean,
So, I mean, I guess my thought is, like Ms. Davis said, I mean, we're not the ones to equipped to decide where this line is, and this only refers to one of the two properties, the red property. I think it was red. I mean, that they are not directly part of this appeal. The appeal is a neighbor. The neighbor is appealing. And so, I mean, I would be inclined to not approve the variance because we're not the ones to equip. The variance is a change from what is known and prescribed. So like, if we're not the ones to do that, then I don't think we can be the ones to approve that variance per se. I know they're trying to do it functionally to try and move quicker, and maybe they can on some of these the other side of it. But that's kind of where I'm sitting right now. Is like, if we're not equipped to do it, then we can't grant a variance, essentially.
I mean, I guess my argument, I'm interested in what our chairwoman thinks because she's scrunched her face. No, that means you're thinking. So I'm interested in what you said, what you think.
Can I add just one thing that may assist this discussion? From the point of view of the zoning administrator, I hold that the Fusan's survey is correct because we've not cited them for a violation of their house, the one in red. So the department is saying, you're good. Now, we have an issue with this gentleman, obviously. Now, obviously his dispute is, hey, their survey might be wrong, but they're going to have to go adjudicate that somewhere else. That's not in front of this board. So to the respect that you grant or don't grant this gentleman's variance, whatever the hardship reasons, whatever it is, whatever your standard is, the Department of Codes and me as the zoning administrator, the Fusons, as far as we believe their survey is correct because we've not cited them to come before this board. We've not cited them to go to environmental court. We don't in any way believe that their home's been constructed wrong. So that's why I do want to go talk to them about their UNO, because from the department standpoint, we think they're good. They may have to litigate that, but it's something.
Right.
I left the last meeting, but then this kind of modeled it for me. Thank you for saying
Sure.
that.
And I think from the standpoint, if it helps us, Liz and I talk to, if it helps us, if we've got one of these where there's property on dispute, I'm almost like, hey, y'all go settle it, bring me a judgment, then we'll decide to hear your case. It's just kind of in this one, we're a little bit beyond that.
So, go ahead.
Can we see the red and blue diagram again? So I listened to the case last night, so it's fresh in my mind. And the attorney that spoke in the last case, who's in the back of the room, I remember him saying something about, for purposes of this case, we're going to go with the line that is red, the property line. And so I guess I was basing everything off the red line, just because of what was mentioned in the last hearing. That's why I was scrunching my face.
No, that's a good point.
So Mr. Hargis, you may be able to help me with this. So say if we, hypothetically, if we deny this variance today, then what course of action? I mean, so then they figure out the survey stuff in a month or two. Who knows? I don't know how long that stuff takes, but they figure out all that stuff, and then they come back to us with a new variance. That's, they decide, okay, we're going to move the garage, and we're going to try and leave the dwelling, and we've agreed with the neighbors that they're okay with it at that point, for whatever reason. I'm assuming that would be a new variance request to us. Is that right?
Yes, sir.
And what is the minimum time frame for that typically?
The board's rules, and I think the ordinance says there's 6 months that the applicant would have to wait to seek the same or similar relief.
Okay.
You all could make a motion.
We could reduce that.
I think to grant that, and Tara and Ann can correct me if I'm wrong, but I think you would need to say, we're moving to waive our rule for this extraordinary reason why, and explain why you're doing the rule on the record in case somebody wanted to appeal it out. But
all right, thank you.
I think you could.
Okay.
So if I understand your previous comment, there is at least assumed the existing folks that can't get their UNO, that their survey is correct based on their prior applications.
Yeah, well, I'm looking.
I mean, I'm not trying to put you on the spot.
I would say, and I said it just a minute ago, I think the department's position is the red survey is correct because I'm looking at their permit, and the young lady had the document there. It's our inspection request form, and we've cleared the items that as far as from a inspection point of view, yep, you're good here. The note on that says hold UNO until this event.
Gee, thanks. I appreciate that.
But I mean, that's something I'd like to go talk to the director and be like, hey, should we really hold these folks? Because, here's the facts that we see it.
So we're sitting here.
We definitely want to hold the blue guys left-hand side. And it's fair, as the attorney represented, we shouldn't hold unit on the right-hand side hostage either because, unless there's some setback issue over on the east side, there's not. So those should be released too, out of fairness to both parties.
So in looking at it, I need to assume that the red is correct based on prior.
I would say this to you. An appeal of my determination is appealable to this board. So my determination is that the red line for the purposes of this department is valid. Now, somebody wants to appeal that and come to this board and go, no way, the blue one's.
But they haven't done that as of this point.
None's been filed. So for the purposes of there and the purposes of what kind of variance is this gentleman asking for, I would say it's reasonable to accept the red line. Now, Chancellor may
But there's a measure of damages to that, is there not?
I would think so at the court level.
Yes,
But
okay.
that's.
And you can put a dollar number on that sometimes.
I don't know what that is, sir.
Understood. Thank you, sir.
So from my perspective, based off of everything we've heard, I think the unit that's not really in dispute, let them get their UNO. I think the opposition, to the extent that Joey and the codes department can, let them get their UNO. And then because really it's that one building in the middle that's causing the issue, because we have testimony that it is injurious to the opposition, which is a standard for a variance. We deny the variance, but we have a caveat that in the event that the applicant has new evidence, they don't have to wait 6 months to come back. They can come back as soon as they have that new evidence and apply for a variance. So that's my proposed solution.
Is that a motion?
If we can
It sounded like a great motion to me.
That was a really good motion.
That was a great motion.
Okay, to the extent that all of what I said was a motion, I do move that. I so move that.
I second it.
I knew Justin was going to come through for us.
We have a motion and a second. Any discussion on that motion? I guess I'll say this is really tough. And I guess I'm sympathetic still to the blue property, the 1042, because they did have a survey that was stamped and they used that survey. And so I don't know if sympathetic is the right word, but we do grant variances into setbacks on a regular basis. This board does. So I don't know. To me, it wasn't as injurious. So I may not vote in favor.
No, that's understandable.
Before we take a vote for us and entering orders, just like you grant a variance, you're saying, here's the hardship I found. You also, in a denial, need to state, here's why I'm not granting variance. And I need you to express that before you vote on it.
So I found that there was not a hardship because of the presumption that the neighbor's survey is correct and they built their property correctly, and then they presented testimony that this building and this garage is injurious to their property. And so based off of those two factors, I found that there was not a hardship, but I recognize the exceptional circumstances of this case. And so if the applicant gets new evidence or new information, they can apply for a variance sooner than our rules permit.
Immediately?
Yeah, immediately. They don't have to wait. Yeah.
And one question before we take a vote. Is there any reason to separate the garage from the dwelling and have two different motions? Does anyone?
That is completely up to you guys.
Yeah, does anyone feel the need to do that?
Administratively.
Okay, we have two of us that think we should take two motions. So do you all agree you need the motions?
So for me, like I mentioned, the side closest to that east boundary is not included. They should get those people should be allowed to move in, as well as the opposition. I have issue with the entire blue building from the house to the garage, because we had testimony that it was too close and that it was beyond that. So that was but if people disagree, that's fine. But that was my perspective.
Well, you have the standing motion, so we'll go with that motion. And you were the second on that motion. Okay, so we'll take a vote. All in favor of that motion, say aye and raise your hand. So we have 4 in favor. I'm opposed, so it passes 4-1. And I think that concludes our meeting for today.
I can't wait to see those.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.